the power of lawyer because I've managed to repel half the number of journalists from the room within moments of me starting to speak. Very good to be here. Good to see you all. So look, it's literally impossible and almost a difficult task to literally summarize the digital laws that will govern freedom of press within a span of 10 minutes. But having said that, let me just divide it into three broad buckets, which is about existing laws and how it's being used by the government, uh, two new proposed laws that we can expect to come our way, which could impact freedom of speech and freedom of press in the digital space. First of all, starting with the existing law. So, as you know, the Information Technology Act is the law which largely governs speech online. And there are broadly two provisions which govern freedom of speech. One is 69A, which gives the government the power to block on specific conditions. So if there is a speech or if there is an article which is relating to which has an impact on security of state, which relates to conducting of a cognizable offense, etc., the government has a power to issue a blocking order and block that particular article or particular news link, etc. Similarly, there is also certain powers that the government has under intermediary regulations to point out to the intermediaries to ask to take these links or articles down. There are also several other laws which has an impact on speech. For instance, there are laws relating to alcohol advertisement, there are laws relating to prenatal pregnancy diagnosis and various other things which also has an impact on speech per se online. Having said that, there is a third trend or a third activity that the government is doing, right? There is a different category of information that could also potentially be blocked online. Let's say there is a speech which is defamatory in nature, right? So the way it works is for government to block a particular order online. For instance, let's say you make a defamatory speech against someone. The government cannot be the arbiter and a decision maker with respect to the fact that that speech is illegal or not. You should essentially file a complaint before the police if it's criminal defamation. The court needs to look at it and say that, look, this is in fact defamatory speech in the prima facie phase, and there should be a court order to take such articles or content down. But having said that, we have seen the government taking a very different approach when it comes to this. What they have done is, you might be aware of the Shreya Singhal judgment, which dealt with the powers of the intermediary. They revamped the intermediary regulations, and there is a new provision which exists, which is known as Section Rule 3D of the intermediary rules. And what the government has done is, government is issuing notices to various intermediaries, including the search engines and social media companies and the likes, specifically pointing out, saying that, look, there is this content which is defamatory for against X person, which has certain other illegal characteristics, etc. And the government is sitting in judgment and making that decision. It is not in exercise of their power under 69A. And that action, and for instance, the very last instance of this action has been the now very famous instance where one particular minister had went on for a long tirade against a particular company because a particular AI algorithm, a Gen AI algorithm, called our prime minister a fascist, right? So as you know, the way algorithm works is, the Gen AI algorithm works is, it is trained on data, and based on this publicly available data, the LLM generates a particular output. And it is not necessarily information that the LLM is itself generating or creating. But apparently, if sources are to be believed, the government felt that that is a violation of the terms and conditions which an intermediary should obtain. And the government has prima facie held that, look, it looks like a defamatory statement and it needs to be taken down. This is one example of the way in which there is an unconstitutional encroachment on the digital free speech on the digital space right now, because the government doesn't have the power to do it. Technically, it needs to be done. Let's say there is an agreed person, that person needs to file a complaint before the court or the police, or file a civil suit, and there needs to be a separate procedure that needs to be done to essentially get an order under which this particular article or link should be taken down. This is a new exercise of power which is currently being unchecked. There are no proceedings, as far as I am aware, which is against this particular provision under the IT rules, but that is currently in operation. Secondly, as you know, under the IT Act itself, there is now it's been challenged before various courts of India. It's now currently pending before the Supreme Court, the Chapter 3 of the intermediary regulations, which deals with how the government can ask a publisher to take down content on the basis of either a fact checking unit which the government institutes, or on the basis of the three-step grievance redressal committee or appellate mechanism that the government has prescribed. While the whole process has now been challenged, even very recently, you saw one of the magazines got an article asking for a specific takedown under some of these provisions. And that's again been challenged before the court. But having said that, that's another unconstitutional way in which government is trying to control free speech online. Moving on to the new laws or the proposed laws that we are that has a potential to encroach press freedom online, and one is actually a very innocuous one. You would never expect a Personal Data Protection Act of a country to infringe on the right of the press. So as you know, we've had a long conversation around the need for a law which protects the personal data of citizens of this country. And after a long wait, we have a draft, we have a Data Protection Act which has been passed by the Parliament, which is not in force, but it's expected that it will come forth somewhere this year. But it has been passed by both the houses of the Parliament, and it has received the President assent as well. One interesting feature of this legislation is that unlike most advanced jurisdictions which has similar laws, they do not provide a specific exemption to journalists, right? What we need to understand is Data Protection Act, what it does is it protects our personal information. So if any company, if the government is collecting the personal data or individual personal data, they need to take our consent and comply with certain mechanisms to ensure that our personal data rights are protected and it's not subject to violation or misuse, etc., etc. But there is what is the problem with lack of an exception for a journalist? So let's assume that you're using certain information about an individual without that person's consent, and you're writing a story or you're writing a feature about that person. That could be alleged to be violating the data protection rights of that individual. So which means that a journalist, if he or she is writing a story about, on the basis of a leaked document or basis of information that is otherwise not available in the public domain, maybe due to a whistleblowing complaint, maybe from a whistleblower sources, maybe from other sources which are not really available to the public source, which has not been given out by the data subject himself on a voluntary basis, the journalist and the media organization could be subject to liability, and which could go up to several hundreds of crores. That's the sort of liability that journalists and media organizations are facing if there is no exemption which is granted to the government. And anyway, Editors Guild Association has approached the ministry and written a statement to this extent. And it's expected, and we are hopeful that some sort of an exception could be given. Having said that, if that exemption is not given, it is nothing but a blatant unconstitutionality that we will have to fight before a court of law. The second law that I'd like to talk about, which is a new proposed law, is actually in the form of the broadcast regulation bill. So as you know, historically, we've had the cable TV regulation network, which governs broadcasting in India. And but the government has the plan to completely revamp that legislation and introduce the new draft broadcasting bill. The intent behind the legislation is not just to govern the traditional broadcasting, which is not your TV and FM and radio and the likes, but also to bring into its fold OTT and, interestingly, social media influencers who also disseminate news and current affairs related information, right? So once the new bill, if it's enacted in the current form, and the bill is currently out for, it was out for public comments for a brief while, the consultation window is closed. But once that, if it's enacted in the current form, what it will entail is that if you're distributing any sort of news content in an OTT format, then you are supposed to register with the government. And similar to a regular periodical or a publication, you also need to disclose your subscriber numbers and comply with certain other criteria that the government is prescribing with respect to continuing your operations regarding OTT. And similar sort of regulations will also apply if you're a news media influencer. If you are someone in, you're making a YouTube video which is disseminating news and current affairs content online, you will also have to comply with these sort of compliances. And one interesting compliance is that you also need to have a specific internal committee to actually review the content that you are bringing out, and you will be subject to various takedown provisions which are currently applicable to other publishers as well. So where does this sort of points to? This sort of points to the trend that the government is actually empowering itself. One, through existing laws they're using in unconstitutional means to actually curb freedom of press in the country. Secondly, they're also bringing out newer regulations, and some of them innocuous as well. When once, for instance, when you look at a data protection bill, the fact that a journalistic privilege or journalistic exemption is not there did not unfortunately receive that sort of attention, because that's not something what you would expect in a data protection bill. So those sort of regulations are coming out. And thirdly, there is new laws which are being planned as well, which could have an impact on freedom of press at large. So I'd like to conclude my remarks with this. Thank you very much for having me.
Hi. Thank you, Anant, and everyone at EGI for having me here as well. I'm Abhinav, as the slide suggests, and while both of our photographs don't really look like us anymore, I can definitely say that Nikhlil has aged a lot better than I have. Having said that, I am here, I'm trying to lighten the mood, because actually the landscape is really not conducive to lightening the mood at all when it comes to criminal law and what journalists must face, right? My presentation is largely going to focus on the new criminal laws, which are due to be introduced from July the 1st now, as news has confirmed. And I have two pieces of good news following, which is primarily only bad news. So why don't I just start with the good news first, which is, first of all, the new criminal laws are not that new. So in a sense that we are not going to be assaulted by a complete overhaul in terms of what the law was, with having to refigure what is going to be the new law. It appears that about 75%, if not more, of the new criminal law is frankly what was already there in the old criminal law. So we don't really have to relearn that much. At the same time, it also means, since the institutions are definitely not changing, we don't have to relearn much at all, might be something that some might say. The other piece of good news, specifically again from a journalist's perspective, might prove to be, and all of this is obviously hypothetical because the laws are not yet in force, there seems to be a little bit of a procedural change when it comes to private criminal complaints. And here I am speaking about defamation specifically, which is a piece in the criminal law that has always been a problem for journalists. Right now, the way the law works is that a person can institute a private criminal complaint anywhere, and then they will proceed to prosecute it, after which the court will decide whether or not to summon the accused person, usually the journalist and the editor, to face trial or not. Two critical changes that have happened are, number one, even before the court takes cognizance of a complaint, that is, before it starts anything to do with the process, the new law suggests that you have to give a right of hearing to the accused persons. So now you will possibly have a right to advance the exceptions to the offense of defamation right at the outset, and therefore that might prove to be a bit of protection. Secondly, the thing about defamation as an offense compared to, let's say, more serious ones, was that the scope to argue for what is called a discharge in the criminal procedure was very limited. Now that has also been seemingly widened in the new law. So there was, where earlier no opportunity to argue, raise proper defenses prior to actually starting the trial and having to go through the motions of a full-on criminal trial, apart from, going to the High Court to get a quashing of the proceedings, so on and so forth. The new criminal procedure may now bring two opportunities where there were none, to try and stymie, malicious prosecutions, if they may be malicious. So that's one piece of good news beyond the more generic good news that I started with. Now the bad. So the new sections on the procedural parts, you may just want to look at sections 223 and 273 in the BNSS. So whenever it does come into force, I just repeat that, 223 and 273. So these are the procedures, and this is in the BNSS, the Bharatiya Nagrik Suraksha Sanhita. I did that for effect. Coming now to the bad news. The first, and again, there's a lot to cover, and I know I'm constrained a little bit by time, so I want to try and be as quick as possible. Someone mentioned UAPA earlier, so let's just start with the fact that now even the General Penal Code, the BNS or the Bharatiya Nyaya Sanhita, is including offenses of organized crime and terrorism. These are in substance not very different from the crimes that are there under the UAPA and other laws such as the Makoka, the Guj Koka, so on and so forth. So in terms of content, there's not much that is different. But what is interesting and will prove to be problematic is the fact that now there will be two parallel regimes prosecuting the same kind of crime, where the UAPA will have its deadly cocktail of restrictive bail, reversing the presumption of innocence, so on and so forth. But the general law will not have that. And how do you decide which specific offense to trigger? The law specifically confers that discretion upon an officer at the level of the superintendent of police to decide whether the UAPA ought to be invoked or whether the BNS ought to be invoked. So that's going to prove to be interesting and challenging at the same time. The second big point was a lot of media coverage was around the potential deletion of sedition as an offense, and the EJI, of course, is, if I'm not wrong, party to proceedings before the Supreme Court challenging the validity of the sedition offense in the penal code. The correct position, according to me at least, would be that sedition in name is no longer there. The Press Information Bureau releases also suggest that sedition has been replaced by treason, which is, that's a convenient way to call that it's been deleted. Because if you look at the literature around the development of the offense, treason is equally, if not more, broad than what sedition is understood to mean. So the Hindi versions of this were saying that the offense of Rajdroh has been replaced by Deshdroh. So take it however which way you will. Just to again look at the language behind these. So the new offense, which is for anyone who's interested, 152, 152 in the BNS, that is what is punishing treason. It punishes acts that are endangering the sovereignty, unity, and integrity of India. So far, so good. But the conduct that it is punishing is anything that may excite secession, armed rebellion, subversive activities, and here's the interesting part, encourages feelings of separatist activities or endangers sovereignty. So how do you encourage feelings in another person is going to be potentially something problematic for courts to deal with. How you may encourage such feelings, so it's not only words either spoken or written or by signs, which is what sedition used to cover, but it is now electronic communication or by use of financial means or otherwise. So again, I don't want to spook anyone here, but the idea that someone is being lawfully employed to do their job is now covered as possibly the means in which you might encourage someone to develop feelings of subversive activities, right? So that's the catch-all nature of the new offense. And I'm personally not very sure if it is any which way narrower than what 124A, which was sedition in the penal code, used to be. Next piece of bad news. Links to what Nikhil was talking about the fact check unit. Again, EGI is there in court on all of these issues, which is a fantastic thing. The fact check unit is there under the Information Technology Act and the regulations. There's an interesting development in the new penal code that sort of marries along with this. That is under 197 of the BNS. That pertains to the existing 153B of the penal code. These are offenses that are punishing anyone who is prejudicing the unity and integrity of India. The addition, which is very interesting here, is anyone who makes or publishes false or misleading information jeopardizing the sovereignty, unity, integrity of India. Now, how do you decide this, right? How do you decide, first of all, whether information is going to be false or misleading? And second and most critical, that information is jeopardizing and not endangering the sovereignty of the country. And the manner in which the criminal law works, which all of us in the room are very familiar with, is that discretion is vested with the local thanedar, the station house officer, the police officer on the ground. And that is the person who has been tasked with making that determination of whether, first of all, a piece of information may be true or false. And secondly, whether that is jeopardizing such a significant thing such as the unity of the country. So those are the important things that I culled out from a journalistic perspective when it comes to the BNS. I already mentioned the good parts in terms of the procedural law. In terms of the bad parts, I think the most significant changes are twofold. One is on arrest and bail. A law that was already very restrictive is now more restrictive when it comes to questions of pre-trial custody and bail. So, for everyone present in the room, a quick reminder that the law as it is today allows police to gain pre-trial custody up to 15 days, where that 15-day period is limited to the first 15 days after an arrest. So once you get arrested, within 24 hours, as per the constitution, a person must be produced before a magistrate, and the magistrate decides whether or not custody goes to the police, and if so, that can only be up to 15 days. So far, so good. The change here that is very confusing and extremely problematic is potentially that period is expanded from 15 to even possibly 60 or 90 days. That's the least charitable reading. The most charitable reading of this rather confusing set of provisions, which is 187 of the BNSS, is that there is 15 days in total, but the provision is now expanding that from being the first 15 days to possibly even later. So where it was the first 15, for certain offenses it may now be the first 40, and for certain others it may be the first 60. So that's the more charitable reading. The problem is, of course, that the law is not framed very clearly, and again it will fall to courts to deal with these provisions if the legislature does not choose to amend it prior to it actually going to court. In respect of bail, a couple of things, actually just one thing to flag here, which was the most interesting and problematic change that I felt. There is in the Indian system a fact of life that pre-trial custody is all pervasive. More than 75% of all prisoners in Indian prisons are under trial prisoners. And the problem was historically so bad that it led to one of the most famous public interest litigations in Husainara Khatun's case that led to the legislature 34 years later coming up with a provision in the form of section 436A that says that anyone who spent up more than half of their maximum sentence as an under trial is now entitled to bail with some conditions, right? So this is a legislative apologia, if any, that if you spent so much time as an under trial, now it doesn't matter what you were accused of, asterisk, you get bail. That asterisk has been widened considerably in the new law. And the most interesting and problematic part here is there will be no right if you are accused, and please mark my words, if you are accused of more than one offense. And anyone in this room who's read an FIR knows that any FIR has more than one offense in it, practically any FIR. And if any FIR does that, then you have in one fell swoop taken away that legislative apologia almost entirely, right? So I thought that was potentially extremely problematic. Again, it'll be interesting to see what courts do with it. An issue which concerns journalists a great deal, and I happen to be part of a litigation that is pending before the Supreme Court, is seizures of devices, right? So there's some people in this room might have had to deal with it face to face. Agencies come, they sort of seal the entire space, they take devices, they take computers, they take personal devices. The existing legal regime in the 1973 code was almost a complete facelift from the 1898 code, which was intentionally made to not grant rights to persons and maximize the scope of power for the police. That didn't really change much. Specifically on technicalities, the older law never even referred to electronic devices, right? So there was a question of, can you even search my computer? Because all that the police could do under the law as it stood then was search physical spaces. So how can you actually search a digital space? All of those questions are still pending. What the new law has done is it's actually not really touched any of that. But what it has specifically provided for is a duty under what is now section 94 of the new law, which specifically says that a person can be asked to provide any electronic communication or communication device. So this corresponds to section 91 of the code. Again, some people in this room may have received section 91 notices from agencies. Those are basically the letters that you get from an agency asking it to give you asking you to give it information. Now that has been broadened to specifically say, please also give us any electronic communication or communication devices. At the same time, there is no sort of corresponding limitation to protect privacy, which has been recognized as a fundamental right, at least as of 2017. So, scope of power broadened, scope of restrictions not considerably broadened as well. Then, which brings me to the last piece of, again, severely bad news. Everyone in this room is obviously familiar with the PMLA. I mean, how can you not be? One very interesting feature of the PMLA is not the prosecution side with its restrictive bail conditions, but its civil forfeiture side, which is the attachment power. So, there is news, and I'm talking to a room full of journalists, there is news about there is an attachment order, a provisional attachment that is confirmed. So all of that is a parallel civil proceeding that happens while the legal process on the criminal side is still pending. And that is based on a preliminary sort of finding that whatever you were doing seems to be related to money laundering. And we are going to attach your assets and you are not going to have access to them till the trial stands concluded. A key critical part of the money laundering regime being that confiscation, that is the right of the state to actually sell your assets, is not getting triggered till you stand convicted of a crime. Well, that has been changed in the new law, which under section 107 has conferred a severely broad power of attachment and forfeiture that allows the police, and not any specifically high empowered officer, any police officer who's investigating a crime, I'm just reading from the statute here, applies to property that may be derived or obtained directly or indirectly as a result of any criminal activity or commission of an offense. So that any criminal activity or commission of an offense is now going to confer powers to take away any property that you might have, seize it, confiscate it, sell it, all during the pendency of your trial. So there can be an ultimate acquittal, but the law doesn't talk about what happens to it if there is an acquittal, right? So again, there can be many ways in which these laws can be weaponized, and it falls to organizations like the EGI, and Anant knows this better than most, to try and spur advocacy around how specific exemptions can be carved out to make sure that these laws are not weaponized in the manner in which we have already seen them in the past. And it's going to be a challenging set of months to follow after July. Thank you very much, and here to answer any questions.